Module 13, Chapter 11, Risk Management, Legal and Financial Safeguards. Learning Outcomes for Chapter 11. In this chapter, you will learn how to recognize and comply with standard and customary event regulations and procedures. You'll learn to read, understand, and evaluate legal event documents. You'll understand and comply with the general requirements of U.S. regulations related to the Sarbanes-Oxley Act. You'll access, plan, manage, and control potential event liabilities. You'll obtain necessary permits and licenses to operate events. You'll learn to develop and manage risk management procedures, understand and comply with environmental regulations governing events, and comply with regulations governing sponsorships of conferences and meetings, and maintain documentary evidence of compliance procedures. All events have these two risks. Risks of negative occurrences, both on-site and off-site, and negative publicity from negative occurrences. Whenever we bring people together for a special event, there are inherent risks, which can lead to long and costly litigation, which you can try to avoid as much as possible by good planning and contingency planning. Sarbanes-Oxley Act. This was a reaction to court actions against the accounting practices of Enron, MCI, WorldCom, etc. You may or may not have heard of it. It applies to publicly held companies, so if you're working for your private firm, it does not apply to you, not at this point. It calls for greater accounting transparency. The noncompliance with this act could result in criminal prosecution. And if your client is a publicly held company, review the legislation carefully and comply with all the requirements as they apply to your organization through your client's responsibilities. Contracts, permits, and licenses. Protect your legal interest. Avoid fines and lawsuits by providing a safe event environment, obtaining all necessary permits, complying with all laws, obtaining legal counsel to review contracts and provide oversight. Fiduciary responsibility to the stakeholders is essential for all event professionals. You have that responsibility to your stakeholders. Honor ethical practices, adhere to the industry code of ethics, and reflect what is standard and customary in the special events industry. More on contracts, permits, and licenses. Ensure safety and security of event stakeholders, both legal and ethical responsibility. The event leader is responsible. Keep that in mind. You as the event leader is responsible, so do not transfer your responsibility to others. You need to provide a safe environment which is free from hazards and a secure environment which is free from harm. You also need to protect your financial investment and as well as your stakeholders' financial investments. Every decision risks unforeseen financial impacts. So anticipate your contingencies by planning. So if something happens and you have the appropriate action in place. Key components of an event management agreement or contract. Parties. This is the agreement between two parties or two or more parties. There's an offer, service or a product to be tendered. There's consideration, what one party provides to the other upon acceptance. There's the acceptance when both accept, and they execute and sign the agreement. So it's important for you to understand some basic legal terminology when you're an event professional. So see the example, the consulting agreement on page 384 to 386 to start to learn some of that terminology if you don't know it already. Other components would be terms, cancellation, force majeure, which is an act of God, arbitration, billing, time is of essence, assignment, insurance, hold harmless and indemnification, reputation, complete agreement, rider, echo rider, changes to the agreement, terms and sequence of execution. These are all very, very common terms in legal contracts. And this may be your first exposure to these terms, and it may be something that you've never heard of, so it's like foreign to you. So have a basic understanding of what each one of these means, because you'll run across these when you're working with contracts, whether it be in the special events area or in another industry. Other agreements. There are many types of agreements for consideration, including consulting agreements, employment agreements, exhibitor contracts, non-compete agreements, sponsorship agreements, purchase orders, permits, local, state, and federal permits, as examples on page 388, alcohol, business, food, music, pyrotechnics, Those would all require permits, licensing, environmental regulations, recycling, reuse, reduction, waste management, sponsorship regulations, international events, visas, work permits. Check with your consulate or embassy if you're going to be doing international events, and some of you may. Contracts, permits, licenses are all a synergistic relationship. You need to do your due diligence well in advance to determine what is needed in your particular event, and also who pays for each of these things. So keep in mind that there are different kinds of agreements that you'll need to be familiar with and understand completely and their ramifications. Risk management procedures. Whenever humans assemble, there are increased risks. Risks of injuries, death, risks of damage to property, theft, risks to reputation, loss of future business opportunities, loss of revenue, an increase in insurance premiums. So you'll want to organize a risk assessment meeting. This is very important to do before the meeting and figure out who the parties are who should attend. You'll develop a step-by-step guide, which is a master list of risks, responsibilities, responses, and also the scale of importance of each. Identify any gaps, what's missing, what haven't you thought about, what needs to be thought about. Plan to reduce, control, transfer, eliminate the identified risks. Conduct and document the meeting. You need to do this to document your proactive approach and also to mitigate possible damages. So if for some reason there was a lawsuit, you would show that you've gone through the planning process and you did your best to avoid any kind of harm. Safety meeting and other considerations. You'll need to hold regular safety meetings, conduct inspections, make sure that the cables are taped, that all electrical power is grounded. You want to keep the work areas free of debris, have no smoking policies. You want to remove all possible trip and fall hazards. You want to conduct inspections on a regular basis and have a zero tolerance for unsafe working conditions. You want to do a final walkthrough and have a checklist before your event happens. Other considerations to take into account when you're doing these special event planning is training. Should you have CPR training? Do the staff know how to appropriately do the Heimlich maneuver? Is that going to be necessary in your event? Would it be possible? You need to document all of this, to keep records, document the risk assessments, the management and prevention steps you're taking to prove your due diligence. You need to obtain insurance, which transfers risk to third parties. This is often overlooked, but it's important. You need properly qualified insurance broker or insurer. You need to identify the appropriate premium for you, the comprehensive general liability insurance, and your client will be named as additional insured. And you may want to be an additional insured on your client's policy as well, depending on the circumstances. So you'll want to check on that if you get into planning large events. Also exclusions. There may be exclusions to take into consideration on your agreements, things that you might exclude. And if there's pre-existing coverage, review pre-existing coverage for any gaps and cover with extra insurance. If you happen to have a basic policy and you're doing something different or special, there may be a rider needed in that particular case. Risk management procedures, risk control. This would be controlling any potential risk associated with theft, cash, inventories, copyrights, trademarks, service marks, registered marks. That's when someone else is using your trademarks illegally and you need to control that. There's a potential for terrorism and biochemical risk. Terrorism these days is something to take into consideration. So you need to be prepared for that if you're having large-scale events. And even small-scale events can have some kind of acts of vandalism or crime associated with them. So your efforts are to control and minimize that. Managing risk is everyone's responsibility. Documentation, discovery, and disclosure, all important. Be prepared to surrender and defend during possible litigation, all of these things. Your contracts, your organizational chart, your risk assessment procedures and risk management plans, your insurance policies and certificates, your budget to demonstrate your investment in risk management. Again, to minimize any potential liability. Once again, managing risk is everyone's responsibility. Documentation, discovery, and disclosure. Be prepared to submit all these things. This is a repeat to emphasize that you may need to produce all of this if you are in a court situation where you're being sued to prove that you've done your best job. So once again, here's the message of plan for the worst and hope for the best.